Hello everyone. So we were discussing part 6 of Indian Constitution, and as part 6 of Indian Constitution we already have delivered 3 chapters. That was chapter on governor, chapter on chief minister and chapter on state legislature. So this structure is structure of the state in Indian Constitution. State has been discussed in part 6 of Indian Constitution. So if you remember, we can recall it. Part 1 dealt with union and territories, part 2 dealt with citizenship, part 3 fundamental right, part 4 DPSP, part 4A fundamental duties, part 5 the union, and this is the part 6 that is dealing with the state. If you see part 6 of Indian Constitution, see there are 22 parts of Indian Constitution, and further these parts has been divided into chapters. So if you could see here, the state has been divided into 6 chapters that you do have. The first chapter deals with the general information regarding the state, rather what is the definition of state, right? So that we already have done. Then second chapter, the executive. So as part of executive, we already have delivered 2 chapters, that is chapter on governor and chapter on chief minister. Advocate general we have kept pending, and when we'll discuss the constitutional bodies, we'll discuss this advocate general as well. And the third chapter that we already have delivered, that is on state legislature. Ordinance making power has been discussed already with the governor, right? So the fourth chapter is also over. Now we are delving into the 5th chapter of the state, or 5th chapter of part 6 of Indian Constitution. So with this we are delving into the High Court. One prerequisite that I would like to state here itself, that before attempting this High Court, chapter on High Court, you must have a strong hand on this Supreme Court, that is Union Judiciary. See, there are certain concepts in High Court and Supreme Court that have wide amount of similarity, like appointment process. So in appointment process, when we'll discuss the appointment of High Court judges, it does have wide amount of similarity. So while discussing this appointment process of High Court judges and Supreme Court judges, we'll just point out the difference. We will not get into the nitty-gritties that how this appointment process of judges have evolved, what was this first judge's case, what is this second judge case, what is this third judge's case. So those nitty-gritties, because in Supreme Court we had spent around 6 to 7 hours. So those 6 and 7 hours we had spent on the concept building, and that's why we will not discuss these things in detail, and that's why I was calling that Supreme Court is a prerequisite for reading this chapter or watching the videos of this lecture. We will not discuss this removal process altogether. Removal procedure, rather we were supposed to discuss in this video itself. This High Court, whole of the High Court will probably be divided into 3 to 4 videos, right? So this removal procedure, when we'll discuss, we'll completely give a go by. I'll simply point out that removal procedure of High Court is almost similar to the Supreme Court, and that's why I was calling the Supreme Court is a must for delving into this chapter. So I hope that prerequisite would be clear. So the only chapter after this High Court, the only chapter that will remain pending with that will be chapter 6 of part 6 of Indian Constitution, that is subordinate court, and we'll do that as well. So I hope the structure, what is the structure of part 6 of Indian Constitution, you will have a clarity on. Now we are moving on to next slide to discuss what is the scope of this video, because High Court, whole of the High Court chapter, as already have been communicated, will be divided into 3 or 4 chapters. So we are going to spend around 3 or 3.5 hours in this chapter as well. So as far as this first video on High Court, let us see what is going to be the scope of this particular video. So we'll first discuss what is the genesis, in what situation this High Court emerged, at what point of time, does it has origin in Mughal times or it has origin in British times, that we'll discuss, and role of High Court. Then we'll discuss constitutional roots of High Court. If you want to trace the origins, or if you want to trace the High Court, in which article or which part or which chapter you can trace this High Court role, functioning, appointment, removal, all those things. Then we'll discuss the appointment procedure, eligibility criteria, oath, and removal. Rather, removal I am not going to discuss. Removal slide has completely been copy pasted from the Supreme Court chapter, because as far as removal procedure of High Court judges, as already have been pointed, is similar to the Supreme Court judges. Rather, Article 217, which talks about the removal procedure of what you call this High Court judges, right? It simply says the removal procedure of High Court judges will remain similar to removal procedure of Supreme Court judges that has been mentioned in Article 124, right? So removal procedure slide I'll not even read, I'll simply give a pass by, right? And in the last leg of this video we'll discuss, rather you have to attempt this MCQ and reply to us into the comment section. One thing I forgot to point out, that was about the articles. So this High Court has been discussed in Article 214 to Article 231. 214 to Article 231, whereas state, whole of the state, that is part 6 of Indian Constitution, has spent from Article 152 to Article 237. All these things we already have covered until here. Now we are delving into this Article 214 to Article 213. In this video we'll discuss Article 214 to 219, and in the coming videos we'll discuss other articles as well. I hope that point would be clear. So with this information we are entering into core of this lecture, that is genesis. So what is the genesis of High Court? So if you remember, when we were discussing Supreme Court, so Supreme Court's genesis we had traced from Regulating Act 7073. That was the very first act that was supposed to regulate the affairs of British India Company. So that was the first act from Britain that we had, right? But Supreme Court started, so that is a contrary information, or that is a curious information, whereas establishment of Supreme Court can be traced in 7073, whereas High Court High Court can be traced from Indian High Courts Act 1861, while our understanding from the kind of integrated judiciary that we do have, so here the bottom of pyramid you have these subordinate courts, in the middle of pyramid you have High Courts, and at the top you have this apex court, that is Supreme Court. So if you go by the logical understanding, the logical understanding will dictate that very first there would have been subordinate court, thereafter there would have been the establishment of High Court, and thereafter you had this Supreme Court. But if you see, Supreme Court came into existence very earlier at the stage, rather until 1861 you had existence of three Supreme Court in three major cities, that was in Calcutta, Bombay and Madras, right? Rather these were three major presidencies that British had until 1861 or 1860, right? So until 1861, until this act came, that was India High Courts Act 1861, at all these three cities you had establishment of Supreme Court, right? High Court was not there until this 1861, right? So I hope that point would be clear. So establishment of High Court at various places through Indian High Courts Act 1861, and the first three High Court were established in 1862. So Act came in 1861, while the establishment of first three High Court that happened at three major presidencies that happened only in 1862. The next High Court, that was fourth High Court, was established in Allahabad. Thereafter you had in 1896 finally that next High Court came in Delhi, and thereafter in each and every province you have this spread of High Court. So this was about genesis of High Court, right? So one information, one learning, or one curious information you have, that establishment of Supreme Court can be traced from, means establishment of Supreme Court as well as High Court both can be traced from British origin, both does have British origin, but Supreme Court's genesis is in 7073 through Regulating Act, while this High Court genesis is in 1862 through this India's High Courts Act 1861. So High Courts were established on a later stage, while Supreme Courts were established at much earlier stage. I hope that point, the genesis would be clear to you. Now we are moving to next slide to discuss the constitutional roots of High Court. So if you want to see the High Courts in present day constitution, you will have to delve into chapter 5 of chapter 5 and part 6 of Indian Constitution. So you have this first article of chapter 5 part 6 of Indian Constitution, that is article 214, and article 214 says that there shall be High Court for each state. There shall be, let me read it again, there shall be High Court for each state. Mind you, it is saying that there shall be high court for each state. It is not saying that there shall be a dedicated high court for each state. I hope you would have understood the difference. It is saying that there shall be high court for each state and not the dedicated high court for each state. So right now we have 28 states, right, but only 24. With the establishment of this high court for Andhra at Amravati, that was the image of high court of Andhra that I had used on this slide. So you have the establishment of high court of Amravati of Andhra. So with this establishment, the number of high court has been increased from 24 to 25. So you have this 28 states and you have only 25 high court, and it is because of this article 231, because article 231 says that the parliament may by law establish a common high court for 2 or more states. Because see, establishment of high courts is not possible for each and every state. We have smaller states like Arunachal Pradesh, we do have smaller states like Sikkim, we do have smaller states like Manipur. All those is Meghalaya, Manipur, Arunachal Pradesh, right? Many of these states that I just cited does have dedicated high court. But the population, if you see, population of these states is very small, and it was because of these reasons that until 2013 the jurisdiction of Guwahati High Court expanded over all the 7 sister states of the northeastern region. So the article 231 that talks about that parliament may by law establish common high court, right? Common high court means there can be one high court only that can whose jurisdiction can expand on more than one state, right? So you can have one state, one UT, or 2 state, or even 7, 9, 10 states can be, and for those 7 or 9, 10 states, right, there can be only one high court. So the meaning of 214, that when you are reading this article 214 that there shall be high court for each state, it should never be construed that it is talking about separate high court for each state, right? Every state will have high court, but they may not have that dedicated high court. They may be sharing their high courts, right, with the other states as well, and that has been mentioned in article 231. That is the last article of this chapter, chapter 5 or part 6 of Indian Constitution. So you have this first article, article 214, which talks about existence of high court for each state, and article 231 that talks about establishment of common high court for more than one state, right? It can be one state, one union territory, 2 state, 1 union territory, or more than 2, means more than one entity. For more than one entity you can have common high court. So right now, as I was talking, that you do have 25 high courts, right? So most of the high court, if you want to remember the seats of the high court, so the common logic is that the seats of the high court means, when I am saying the seats of the high court, I am talking about the physically where these high courts are located. So most of the high courts are located physically in the capitals of the states where it is located, but I am saying most of the high courts are located in the capitals, right? Not all the high courts are located in state capital itself. So there are 25 high courts, and all the physical location or all the physical capital you need not to remember. What you can do is that out of these 25 high courts, right, you can just remember the seats of those high court which are not located into the state capital. So there are, let us remember, instead of having list of these 25 high courts, let us have the list of those high courts whose seats are not located in their state capitals, right? If you could remember those high courts, right, you can easily remember the other high courts, because the other high courts would obviously be located into their state capital. So if I talk about, you have Himachal Pradesh. So Himachal Pradesh high court will be located in what you call its capital, right? You have this Delhi high court. So Delhi in Delhi, Bihar in Patna, right? Jharkhand in Ranchi, right? So these kind of these high courts, Tamil Nadu in Madras, right? You have this what you call Telangana in Hyderabad, Maharashtra in Mumbai. So these high courts are located in their state capital. So let us see all those high courts which are not located in their state capital, and so you can easily remember the other high courts which are located in their state capital. So let us have that list first and thereafter the other list, right? So you have Uttar Pradesh. So Uttar Pradesh High Court, rather high court is called Allahabad High Court. So Allahabad High Court does have jurisdiction over, right? So it is never said, see, a technical language in polity, you never say the Uttar Pradesh High Court, rather it is said that the Allahabad High Court. I hope you would have understood. This Allahabad High Court does have jurisdiction over Uttar Pradesh. So logically, if you would have gone by, right, if you do not remember, if you do not go by the constitution, if you would have gone by the logic, you may say that Uttar Pradesh, what you call capital is in Lucknow, so it should have been based in Lucknow, but it was started back by British itself, and it was established, the seat of this High Court for Uttar Pradesh was established by British itself in Allahabad, and since then it is existing there in Allahabad, right? So this is the first state. So instead of being in Lucknow, the seat of although in Lucknow it does have a separate bench, right, but the principal seat of Allahabad High Court is in Allahabad. For Odisha, rather than being in Bhubaneswar, it is in Cuttack. Similarly, for Rajasthan, rather than being in Jaipur, you have in Jodhpur. For Madhya Pradesh, not Bhopal but Jabalpur. For Kerala, not in Thiruvananthapuram but Ernakulam. For Gujarat, not in Gandhinagar but in Ahmedabad. Rather, these Cuttack is more famous in Odisha. Cuttack is more famous than the Bhubaneswar. Bhubaneswar is a newly built, newly designed city. Similar case with Kerala, similar cases with this Gujarat. Gandhinagar is newly developed city. Then this Ahmedabad. Ahmedabad was developed much earlier, right? Chhattisgarh, Bilaspur, not Raipur. Then Uttarakhand, Nainital. Andhra Pradesh, Amravati, not Hyderabad, right? So if you could remember the principal seat of these high courts, right, other high courts that you do have, those high courts are located in the state capital. I hope that point you would have understood. Now let us talk about these common high courts. So which are all high court that we do have that does have jurisdiction over more than one state or one union territory, or 2 state, 3 state, 4 state. So let us talk about those high court which does have jurisdiction over more than one entity. Rather than calling 1 state, 1 union territory, or 2 state or 3 state, let us call that courts that does have more than jurisdiction over more than one entity, right? So these are the high court that does have a jurisdiction over more than one entity. So first you have this Guwahati High Court, which does have jurisdiction spread over these 4th northern state. So you have this Arunachal Pradesh, Assam, Nagaland, and you have this Manipur, right? Rather, until 2013, the jurisdiction of Guwahati High Court expanded over all these 7 sister states, right? It was only in 2013 that these 3 states, that was Meghalaya, Manipur, right? This was actually Mizoram, right? So Meghalaya, Manipur, and Tripura, right? So these 3 states only in 2013 got their separate high court, right? So right now the Guwahati High Court does have jurisdiction only over these 3 these 4 states rather, right? Although the Guwahati High Court sits in the state capital of these states with separate benches, but as far as principal bench is concerned, principal seat is concerned, the principal seat of Guwahati High Court is in Guwahati. So that was the first high court which does have jurisdiction over more than one entity, means 4 states. The next is Calcutta High Court, Kolkata High Court, right? So it does have jurisdiction over West Bengal plus adjoining union territory, that is Andaman Nicobar, right? These 2 entities. Next come your Madras High Court, located in Chennai, right? And it does have jurisdiction over Tamil Nadu and 1 union territory. What is this adjoining union territory? Can somebody point it out? So Puducherry or Pondicherry. Then you have the next, that is Kerala, right? Kerala's High Court is located in Thiruvananthapuram, No, we just read Ernakulam, right? So it does have jurisdiction over, again, adjoining union territory. What is the adjoining union territory? Here, so here you have Lakshadweep, right? Then you have this Bombay High Court, right? So along with having jurisdiction over Maharashtra, it does have a jurisdiction over adjoining union territory, Daman Div, Dadra Nagar Haveli, right? So you had these two union territory earlier, but now it has been merged. So these two union territory are now considered as one UT, right? Dadra Nagar Haveli, Daman and Div, right? Then you have this Punjab, Haryana and Chandigarh, right? So Chandigarh is a UT, Punjab and Haryana are two separate state, and Chandigarh High Court, right? High Court is located in Chandigarh, and Chandigarh High Court does have jurisdiction over all these three entities, that is two state and one UT. So I hope the High Court, which does have common jurisdiction, or which does whose jurisdiction extends over more than one entity, you would have clarity on by this structuring. Let us revise it. So you have this Guwahati High Court, 4 state, Calcutta High Court, 1 state 1 UT, Madras High Court, 1 state 1 UT, Kerala, Ernakulam, right? So 1 state 1 UT, similarly Bombay High Court, 1 state 1 UT, then Chandigarh High Court, 1 state 2 state 1 UT, right? So that was about these High Court which does have jurisdiction over more than one entity. Next article is Article 216, which talks about number of judges. So number of judges, see, in Supreme Court how many judges you had? So after that amendment in 2019 you have 33 plus 1, right? So in Supreme Court this is but in various you have this 25 high courts, and depending on the load, depending on population of each state, the number of judges may vary from state to state. So right now you have UP, which does have highest population, and of course means number of cases, because of population, number of cases or case load on Allahabad High Court will be highest. So number of judges in this High Court, Allahabad High Court, is highest, right? So this number of judges are decided. So first thing that should pop up in your mind, that number of judges are decided by which entity. So logically, if you go by the what you call logic, so you might say that number of judges can be decided by the governor, but no, that is not the case. Number of judges here as well is decided by the president itself and not the parliament, right? So in prelim there may be an option that number of judges in high courts are decided by, and that's why, see, wherever there can be chances of confusion, that's why I keep adding another word and I keep striking that through. So number of judges for the high court is not decided by the parliament but by the president. So article 216 talks about the number of judges. So every high court shall consist of chief justice and such other judges, and when it is saying such other judges, it is talking about class of judges. So class of judges, you have this first of all chief justice, then you have another other judges, right, that is permanent judges, and then you can have another category of judge, that is additional judge, right, who will be appointed. What is this additional judge? We will study in the next video. As of now, just have the information that as and when the load of the cases in particular high court increases, so depending on the load, if the permanent judges of that particular high court are not able to handle those increased load, so in that case the additional judges can be appointed. Now who will be appointing this additional, who does have authority, whether president does have, whether parliament does have, or only chief justice with his will can appoint this additional judges, that is the matter that will be discussed in that video itself. But when I am discussing these such other judges, I just wanted to let you know that there is something called additional judges as well. Then you have what you call acting chief justice, and another class can be acting judges as well, right? So these are the different classes of chief justice or different classes of judges that you may have, right? So article 216, again 215 I have deliberately left. We have discussed this 214. 215 I have left because 215 will not fall into the float. 215 actually deals with the contempt and the court of record concept. So that we'll discuss in the later slides, right? Rather later video. So 215 I have left. This is Article 216, and that deals with every high court shall consist of this Chief Justice and such other judges as the not the Parliament, the President may from the time to time. Why this may from time to time? Because depending on the case load, you have civil cases, you have this criminal cases which is increasing day by day. Every passing year load of the cases in these high courts are increasing. So that's why from time to time deem it necessary to appoint. So the learning here is that it is the President who is going to decide that what will be the number of judges. And when I am saying President, it is not President but Cabinet ultimately, because President does not do anything on his own. So ultimately Central Cabinet that will decide, right? So here I have taken a snapshot from the Wikipedia. So the credit goes to Wikipedia. So you have this permanent judges that I was talking about. Then the next class is additional judges. So if you take the example of this Allahabad case, so you have lesser number of permanent judges and more to tackle the increased load of the cases, more number of additional judges. And these additional judges, let me tell you, these are not permanent judges, but their tenure is limited only to 2 years. Later on, if they work efficiently, right, they can be promoted as a permanent judge as and when. Means that entirely depends on some system. That system we'll talk about, that in what all situation these additional judges can be made permanent. Main point that I wanted to discuss, that you have more number of additional judges, that is non-permanent judges, and lesser number of permanent judges that you do have in. And so that if you take into account, if you add this permanent judge and additional judge that you have, right, in Allahabad court you do have total number of 160 judges. Similar case is with Bombay High Court. So in Bombay High Court you have 71 permanent judges but lesser number of additional judges, 23, and that translates into 94. These numbers you need not to, just it is for analytical purpose that I have given you. So you have Sikkim, which does have only 3 permanent judges and 0 additional judges. Similarly Meghalaya, this Meghalaya case you would have heard because recently you had one infamous transfer from Tamil Nadu Madras High Court, right, to this Meghalaya High Court, right, about this TN. One lady from Madras High Court, I don't exactly remember her name, but she had resigned. She was supposed to be Chief Justice of Madras High Court and she was transferred to this Meghalaya High Court. Means her administrative handling capacity or the experience, considering her experience that she had been in Bombay High Court, she had been in this Madras High Court. So considering her, means that transfer was considered as punishment transfer, and ultimately she took that it was a humiliation or punishment transfer and she finally resigned. So that's why this Meghalaya High Court was in news recently. So these numbers you need not to, there is complete no, even in state services these kind of questions are not asked. This is just for your broader understanding that I have put up, right, just to let you know that there is something called permanent judges, then you have additional judges, right. So these are the things that I wanted to point. So this was all about this Article 216. If I talk about Article 217, and in Article 217 you have method of appointment, you have method of removal, then who will be appointing authority in case if high court judges are resigning, then who they will address their letter to. What will be the qualification if a member wants to be chosen into the High Court, then what qualification he or she or that candidate needs to have. So that kind of thing. So method of appointment, appointing authority, the qualification, how they will be removed, High Court judges will be removed, and resignation process, all these things has been discussed in Article 217. So see, as far as this removal is concerned, removal is, as has already been pointed out, that the removal procedure of Supreme Court judges has been discussed in Article 124, and similar removal procedure that you do have for High Court judges as well. So this removal procedure will not discuss. As far as this method of appointment, appointing authority, so let us start discussing this. So we are starting with Article 217 first point, and this first point is that every judge of the High Court shall be appointed by the governor. No, they will be appointed by the president. you go by the logic, you might say that Supreme Court judges are appointed by President, then High Court judges, because it is at state level, High Court judges should be appointed by governor. So you need not to go by the logic in this case, because when we were reading this parliamentary chapter, so you might again say that equivalent of PM is CM, and when PM is being appointed or being administered oath by the president and CM by the governor, then why not this logic, why not to apply this logic here? But the logic should not dictate this appointing authority here. So High Court judges as well will be appointed by none other than the president and not by the governor. So be clear on this point. Now there are two kind of judges, Chief Justice and permanent judges or other judges, right? So this Chief Justice of High Court will be appointed by the president, but president will not appoint Chief Justice of High Court at his own, right? He will be appointing Chief Justice of High Court with the advice of a collegium, and that collegium will consist of Chief Justice of India. One thing you need to careful about that, along with this throughout this whole chapter I'll be using this shorthand, and shorthand will be wherever I'll be writing this CGHC, that will refer to Chief Justice of High Court, and wherever I'll writing this CGI, that will be meaning Chief Justice of India, right? And the collegium, another thing that you need to be cognizant about, this size of collegium. So size, the meaning of collegium you already know, the size of collegium will keep varying. So somewhere it will be CGI plus 2, right? Somewhere it will be CGI plus 4, at somewhere it will be rather CGHC plus 2, at somewhere it will be CGHC plus 4, rather this CGHC plus 4 is nowhere. So these are the sizes of collegium that you are going to see in this video, CGI plus 2, CGI plus 4, because when we'll talk about the transfer of the judges, the size of collegium will be not plus 2, rather 4, and it will consist of Chief Justice of India plus 4. When we'll discuss the appointment of normal judges, means normal judges means I'm not talking about their mental status, means permanent judges, judges other than Chief Justice of High Court. So there you will see the combination of the collegium. So collegium will consist of Chief Justice of India plus 2 as well, and Chief Justice of High Court plus 2 as well. You will know, right? When we'll discuss these things, you will know. So the only pointer here was that wherever I am pointing out, wherever I have written CGHC, it will refer to Chief Justice of High Court, and CGI Chief Justice of India. So Chief Justice of High Court, every High Court will be appointed by the president, but president will appoint this Chief Justice of High Court with the advice of Chief Justice of India plus 2, that will be the collegium size, and with the state governor, means if Patna High Court Chief Justice has to be appointed, right, the advice of Bihar governor will also be taken into account. Now you might raise a question that if you are appointing Chief Justice of High Court of Guwahati, right? Guwahati does have what you call jurisdiction over more than one state. It does have jurisdiction over 4 states, right? So in that case, the advice of all 4 governors, right, 4 governors of all those 4 states will be taken into account. I hope that query would have been resolved. So this is what this Article 217 talks about. Besides this Article 217, there is something called MOP, Memorandum of Procedure, and that has not been discussed in your Lakshmikant. So if you go, so see, this is the constitutional line, right, that he'll be appointed by the president, and president will take advice of this collegium, which will consist of Chief Justice of India plus 2 senior most judges and the governor. So this is the thing that has been mentioned in this Article 217. But as I told, that there is something called MOP, Memorandum of Procedure, that has been signed. This Memorandum of Procedure is nothing but it is an understanding between executive and judiciary, right? So the actual procedure, if you want to say, that will be on top of, and this actual procedure may not be asked in exam, but if you want to have knowledge, right? So this is the flow chart for this memorandum, how actually Chief Justice of High Court is appointed, right? So this is the flow chart. Let me discuss it. Let me quickly cover it. Although again I am giving you raising that point that this might not be useful, that utility for the exam for this UPSC prelim, but that will increase your knowledge, and that's why I have put up this information, right? So see, for the appointment of Chief Justice of High Court, the collegium will consist of Chief Justice of India plus 2, but in actually the thing happens, see, the collegium will remain this Chief Justice of India plus 2, and they will have an idea that okay, these are the applicants or these are the eligible candidates, so they will have a pool of eligible candidates. So if suppose I am talking about Allahabad High Court, so Allahabad High Court may have this as we already saw that there were 76 judges there, right? So not only their choice will be Chief Justice of, while selecting Chief Justice of Allahabad High Court, the choice will not only be limited to the judges of the Allahabad High Court, they may go to the other high courts as well, means other high court judges are eligible for this pool of talent. So CGI, Chief Justice, this collegium will consider the application of all these people, right? And again I am giving a pointer that not only Allahabad High Court judges candidature will be considered, judges of other high courts candidature can also be considered, right? So that will be the collegium that will be that will have opinion on all these pool of talent. Thereafter, besides this collegium, they'll also, this collegium will take advice of one particular judge in Supreme Court, right, which does have knowledge about functioning of Allahabad High Court, because in Allahabad High Court the Chief Justice has to be selected. So how they are functioning, how their administrations run, right? So one Supreme Court judge which does have knowledge about the administration, which does have knowledge about the functioning of his idea will also be, although again I am pointing out, see, the collegium will be only CGI plus 2 senior most judge of the Supreme Court, but they will take opinion of one judge who is convergent with the affairs of the Allahabad High Court, right? So after having finalized that list, that okay, out of this available pool of talent we have selected one candidate, right? So that one candidate name will be forwarded to Ministry of Law and Justice. Thereafter Ministry of Law and Justice will forward that name to the state government, right? So now about that particular one judge, right, state government will also have some information, because you have this state also does have some intelligence agencies, you do have CIDs, right? So about that particular judge, maybe that state government may have some information on his character, state government may have certain information regarding certain cases, maybe there may be not established legal cases, but there are chances that there may be some kind of rumor on his integrity. So in that case, state may raise objection on that particular name that has been forwarded by this collegium. Similarly, Ministry of Law and Justice Affairs will also have some kind of INB report, right? They do have also some intelligence, and if there is cogent reason, if there is serious reasons, right, serious objection that these combined, Ministry of Law and state government combined, have with that particular selection, then Ministry of Law and Affairs may return that file with the noting that hey, we do have certain objection about the name that you have sent. Can you reconsider that advice? Can you reconsider? After that, collegium will sit again, and collegium may see, now it entirely depends on the collegium whether they want to reconsider the advice that had been sent by the Ministry of Law and Justice Affairs, and all these things will happen in written format. It is not that oral, hey, this Chief Justice, we have some serious doubts about this, no, that kind of thing. All these notings will happen on the file, right, that will be substantiated. This Ministry of Law Affairs, if they are saying something, they'll cite this INB report. If state government is citing something, some objection, they'll cite this CID report, right? So now it entirely depends on Chief Justice of India led collegium whether they want to reconsider the advice that has been sent by Ministry of Law and Justice Affairs combined with the state government's advice. If the CGI led collegium advises again with the same name, Ministry of Law and Justice Affairs will have no option than forwarding this file or this name to the PMO, and finally PMO will send this file to the president, and secretary to the president finally will approve or announce the candidature of that person for the chief justice of that particular high court. Thereafter, that medical certificate and medical fitness certificate that will be given by this particular high court judge to the state government, and finally he will be appointed. I hope the process of appointment of Chief Justice of High Court would be clear to you. So this was about the memorandum of procedure regarding Chief Justice of High Court's appointment. Now if I talk about the normal judge, means normal judge, again not the mental status I am talking about, the permanent judge other than Chief Justice of High Court. So this is how he is appointed. So see, two entities will remain similar. You had this Chief Justice of India plus 2 collegium, so that is similar here as well. The second, the governor, so these two entities are common. Now the third entity that you have is Chief Justice of High Court will also be included, right? So he will be appointed a permanent judge other than Chief Justice of High Court will be appointed by the president, similar entity, but with one additional advice. Earlier Chief Justice of India led collegium was giving president advice and governor was also advising, right? These two entities were being consulted. Now the third entity that is being consulted is Chief Justice of High Court, right? So you have these three. Let me clear this board. So you have three entities, Chief Justice led collegium, then Chief Justice of High Court, that particular High Court, and then governor, right? So these three entities are consulted by the president, by the president in the appointment of judge. Again, if you want to see the flow chart, exact process that has been defined into the memorandum of procedure. So this is the exact flow chart, right? So when a vacancy is supposed to be created, again let us take an example of Allahabad High Court. So suppose there are 2 vacancies that is being created, that is supposed to be created in December, right? So prior to creation of this vacancy, 6 months prior to creation of this supposed vacancy, Chief Justice of that particular CGHC, Chief Justice of that particular High Court will start the process for selection of judge or selection against that vacancy, right? So Chief Justice of, not of India, but Chief Justice of that particular High Court plus 2, means this collegium will consist of Chief Justice of High Court plus 2. They will consider the applicant. So there may be advocates who are eligible, right? What is the eligibility criteria for being appointed as High Court judge? We'll see into the next article, rather in 217 only discuss, not next article, article 217, that is the same article that we'll discuss, that will talk about the so eligibility criteria we'll discuss. So whichsoever, either advocate or additional judge who is eligible, so their talent, right, their pool, you do have again this pool of talent, right, that is available at the disposal of Chief Justice of High Court, right? Although in when we were discussing this broad idea, right, we said that it will consist of Chief Justice of India plus 2. So that is the here, right? We'll discuss the detailed procedure, right? So you need not to be confused, but the process will start from here. The final call will be taken by the Chief Justice of India whether to consider the advice of Chief Justice of High Court or not, but the process starts from here, right? That is my point. As far as for exam, you just need to remember these 3 entities. Here we are talking in detail that how actually the process works, right? So here you have this Chief Justice of High Court, that particular High Court. He will have this pool of talent, whole pool of the talent that has to be considered. So you may have some advocate, you may have some additional judge who needs to be elevated to these permanent judges, right? So this collegium, Chief Justice of High Court plus 2 judge, right, will consider the candidature of various advocates, various additional judges, right? And whichsoever 2 candidates are most fit in their opinion, in this collegium opinion, their names will be forwarded to the Chief Minister of that state. So you have this executive hand, but again this executive hand is not going to act as a determining factor. So this is not an executive interference, but a minor executive role. At the same time, even if a Chief Minister, in the opinion of Chief Minister, if there is any one candidate who is fit for the consideration of this judge post, Chief Minister as well can give prior advice to this Chief Justice of High Court led collegium, but only when this Chief Justice of High Court led collegium advises, then only this name will be forwarded to the Chief Minister. Chief Minister can advise this collegium, but Chief Minister will consider only those names which has been forwarded to the Chief Minister, right? So ultimate deciding authority is this Chief Justice of High Court plus 2 judges. Now this file will be sent to the governor. If the process has to be expedited, means if this judge feels, Chief Justice of High Court feels that he or she or his court does not have much time and this whole of the process is going to take the time, so the same file along with being sent to the CM, it can be sent parallelly directly to the governor as well and directly to the Ministry of Law and Justice Affairs as well. I hope that point you would have understood. Once file has reached from CM to the governor, governor will not take more than 6 weeks. So within 6 weeks, this file needs to be sent to the Ministry of Law and Justice Affairs. If within 6 weeks, if this file is not received, then Ministry of Law Affairs, Law and Justice, right? They already have file and they might consider it that governor does not have any kind of objection from the name that has been sent by this collegium that consists of Chief Justice of High Court plus 2. Once Ministry of Law and Justice Affairs has received that file and if they have received any kind of objection, so with that kind of their notings as well as the notings from the governor, that is state government, right, that will be sent by to the Collegium of Chief Justice of India plus 2. So the collegium at the central level, at the Supreme Court level, will consist of Chief Justice of India plus 2. So this is here, right, Chief Justice of India plus 2. Now here what will happen? They will consider the names that has been sent, that has come by this flow. They will consider the name and the weightage will not be given to the advices of, means some kind of weightage can be given to the advices of Ministry of Law and state government, but again unless there is some compelling reason or some compelling allegation on the name, on the recommendation that has been sent by the Chief Justice of High Court, right, they'll approve that name itself. If there is some serious allegation or serious allegation on the character, on the integrity of the person that has been nominated, that has been suggested by the Chief Justice of the High Court, then they may take some kind, they may what you call change the name Chief Justice of India plus 2, right? They may change the name without asking even this Chief Justice of High Court, right? So ultimate deciding authority is this Chief Justice of India led collegium, and this collegium will consist of Chief Justice of India plus 2 judges, 2 senior most judges of the Supreme Court. While taking the decision, this collegium will take the advice of the judge of Supreme Court, not the judge of the High Court. They will take, see, collegium, again I am pointing out that collegium which is considering the advice that has been sent or the name that has been sent by the Ministry of Law. So that collegium consists of only Chief Justice of India plus 2. I know this process is going little difficult or confusing as well. At the end of day, see, at the end of day you have to remember only these things, not this flow chart. This is your extra information that I am adding, right? So just a moment. So here this collegium will consider the advice, means weightage will be given more to the names of this Chief Justice of High Court, the name that has been sent by this collegium, but their advice will also be heeded on, but their advice will be heeded only when the allegation or the notings that they have sent on this name, right, only when they have some kind of serious problem and serious substantiated report against that name that has been sent by this collegium, only then the name will be changed by Chief Justice of India plus 2. If the Chief Justice of India led collegium does not find truth into the allegation that has been made, so any kind of allegation can be made by the executive, and if Chief Justice of India does not find any kind of allegation into what you call reports of these Ministry of Law Affairs and the state government, they may send that file or the name, clear that name within 4 weeks and send that file to the Ministry of Law and Justice Affairs. Now again, if there can be any kind of objection to the notings or the name that has been sent by the Chief Justice of India led collegium, there can be one more return from Ministry of Law that, hey, the name that you are suggesting or the name that you are you need to find whatever basis that we sent to you regarding that particular, at least you confirm it, right? And if again, it will be incumbent on Chief Justice of India whether they want to consider the advice of Ministry of Law and Justice Affairs or not. If this time again with the same recommendation of Chief Justice of India led collegium sends the file, Ministry of Law and Justice Affairs will have no option than recommending that name to the PMO, and that job will be done in less than 3 weeks, not more than 3 weeks needs to be taken by Ministry of Law and Justice Affairs. Thereafter PMO and PMO to President. President finally will appoint that particular candidate to as judge of that particular high court. I hope the process, I know the process was a little lengthy and little complex to be understood. That's why I am saying that you need to just remember only these two things, right? That Chief Justice of High Court will be appointed by the President with the advice of Chief Justice led collegium, which will consist of 2 senior most judges and the governor, while judge will be appointed by Chief Justice of India led by President with the advice of Chief Justice of India led collegium. Collegium will consist of Chief Justice plus 2 judges, but this collegium will take advice of or will take opinion of 1 judge from the Supreme Court which does have knowledge about that particular high court. Then Chief Justice of High Court, that particular in which this judge has to be appointed, his opinion will also be taken into account and governor's opinion will also take. So this is the only thing that you need to remember. As far as these flow charts are concerned, these flow charts has only been added to increase your, to supplement your knowledge, right? So that's the point. So this was about the appointment of the judges, appointment of Supreme Court, High Court Chief Justice and judges. Right? What about the qualification? What qualification a person needs to have in order to be selected as judge into the High Court? So these are the qualification that one candidate needs to have, and that qualification has been mentioned in Article 217. So Article 217, along with discussing this appointment, along with qualification, along with this removal. So Article 217 does contain a lot of things. So the same criteria, A plus B criteria that we discussed into the Supreme Court. So one person needs to fulfill this A plus B criteria, where A is mandatory, he or she needs to be citizen of India, and in B portion you have these 2 options. So out of these 2 options, if a candidate fulfill any one of the options, then he or she can be appointed as judge into the High Court, right? So what are these 2 options? So he should have held 10 years into the any of the judicial office, or he should have held, or he should have been advocate for 10 years in any of the High Court, or more than 1 High Court, or 2 High Court, or 3 High Court. So either 10 years. So 10 years is common. 10 years he should have held as a judicial officer, or he should have been advocate in any High Court or more than 1 High Court, right, for 10 continuous years, right? So out of these 2 options, any one option, and this is common, that is he should have been citizen. So that was the about the qualification for a member to be chosen as judge into the High Court. What about the term? So see, term of Supreme Court judges, if you remember, this point we had discussed into the Supreme Court lecture as well, and we are discussing this High Court lecture as well, that the tenure of High Court judges or Supreme Court judges has not been defined in the Constitution. You have various statutory bodies, you have various constitutional bodies like CAG, you have Election Commission, you have these UPSC, then statutory bodies like NHRC, CVC. So their tenure is defined. Their tenure, constitutional bodies, it is 6 years. For a statutory body, it may be 5 years, or for CVC, it is 4 years, right? So similarly, the tenure of these High Court judges and Supreme Court judges has not been defined into the constitution, that he will be once appointed, he will be in this office for 4 years or 5 years or 6 years or 10 years. That has not been defined into the constitution, and rightly so, to ensure their independence. That has not been defined. The only thing that has been defined into the constitution, not even the lower age qualification that to be appointed. So if one person wants to contest election as MLA or MP, right, there is certain age criteria that he should be of 25 years. If he wants to contest election of MLA MP, he should be of 30 years. In case of one person wants to be appointed as president, he should be of certain minimum age. So neither the minimum age criteria has been defined into the constitution for a member to be chosen either judge in High Court or Supreme Court, nor the tenure like the constitutional or statutory bodies whose tenure has been defined. So these two things has not been defined into the constitution. So as soon you have fulfilled these eligibility criteria, does not matter you have fulfilled this criteria or at the age of 32 or 35 or 45, you can be appointed into the High Court as judge. And once you have this joined as a judge into the High Court, the upper age limit only has been defined into the constitution. So into the Supreme Court case, the upper age limit was 65 years, and into High Court's case it is the 62 years, right? So if any person has joined this High Court at the age of 45, then he is going to last until he attains this age of 62 years. So that is the thing that I wanted to point into this term section. Besides this term, right, he can vacate his office by writing resignation letter to the president. So his resignation letter, High Court judge's resignation letter, will not be addressed to the Chief Justice of India. Again, if you go by the logic, you might argue that if High Court's judge has to resign, right, he might address his letter to Chief Justice of High Court, or if Chief Justice of High Court has to resign, he might address his letter to Chief Justice of India. But no, that's not true. Any judge, if he or she, whether of High Court or Supreme Court, if he or she is intending to resign, he'll address his or her resignation letter to President. Besides vacating his office by writing letter to the president, there is another method by which office of these judges can be vacated, and that is by process of removal. I am deliberately not using the word impeachment, because if you remember into the Supreme Court lecture we had discussed that what is the difference between removal and what is the difference between impeachment. Impeachment in constitution has been used only into the relation of removal of president, and not into the removal of any other constitutional or statutory body. Although this word impeachment has been used into the Judges Inquiry Act 1968, which dictates actually that how the judges will be removed. We'll see in that slide. But as far as impeachment in constitution is concerned, in constitution it has been used only into the relation of impeachment of president, or not for any other constitutional functionary. I hope that point would be clear. Next point, post-retirement High Court judges. So post-retirement High Court judges cannot practice in those courts. Mean practice, when I am saying practice as advocates, right? So if they have retired at the age of 62, so they still have talent. If they are productive enough, if they have not become very feeble, right, means physical capability I am talking about, so they do have wide amount of experience. And any judge, of course, if he or she do have this financial aspiration, he would like to practice as advocate. But there is a limitation that has been placed, that these judges, those have been retired from High Court, right, they cannot practice as advocate in those high courts in which they have remained judge. So suppose a particular judge in his length of service was 25 years, suppose, and in those 25 years if he has served say 5 high courts, so in those 5 high courts he cannot practice as advocate. So HC judges can practice as advocate in court or courts, right, where he or she has been he has practiced during his her career. I hope I would be clear on this term point as well. As far as removal, so removal procedure I am not going to discuss, because removal procedure of High Court judges, as has been pointed, is almost, not almost, means completely similar to the removal procedure of the Supreme Court. Only let me discuss these points. So removal procedure of High Court judges, that has been discussed in Article 217. So Article 217 simply says that the removal procedure of judges will be same that has been mentioned in Article 124, and Article 124 actually talks about the removal procedure of Supreme Court judges. And it is not only Article 124 which wholesale talks about the removal procedure of Supreme Court judges. Actual procedure has been mentioned by this in this Judges Inquiry Act 1968, right? So what will be the flow chart that we'll discuss? So the point, the learning on this slide is that the removal procedure of High Court has been along with being mentioned into the Constitution, Article 217 and Article 124, right? It is also mentioned into the Judges Inquiry Act. And the word impeachment that I was talking about, the word impeachment has not been mentioned in Article either 217 or Article 124, Article 124 for SC judges, right? So that has not been mentioned, that word has not been mentioned into these two articles, rather that word has been mentioned into the Judges Inquiry Act. So while attempting any kind of prelim question, you need to be very cognizant that that word has been asked whether into the relation, in relation with the constitutional articles or this Judges Inquiry Act. I hope that point would be clear to you. So this flow chart about the removal procedure, right, that we are not going to discuss, because this flow chart we had discussed in very detail when we were discussing, and that discussing the Supreme Court, and that's why I said that for prerequisite for this chapter is to Supreme Court. So procedure is going to remain completely same, and that's why we are not covering this removal procedure. As far as oath of Supreme Court judges is High Court judges is concerned, so oath will be administered. So here one difference, see, appointment happens as far as appointing authority of the Supreme Court judges is concerned. So High Court judges is concerned, so appointing authority for this High Court judges is President. As far as Supreme Court judges appointing authority is concerned, for Supreme Court appointing authority as well as oath will also be administered by the President. But as far as this High Court judges is concerned, High Court judges will be appointed by the President, but oath will be administered by the Governor. So that is one difference. Again, I am pointing out that Supreme Court judges will be appointed as well as their oath will be administered by President or some person appointed by the President. But as far as these High Court judges is concerned, High Court judges are appointed by the President, but they are administered oath by the Governor, right? So that oath has been mentioned into your third schedule. This is the content of oath, right? So oath of High Court judges has been administered or is administered not by the President, by the Governor or any person appointed by him, and that has been discussed in Article 219. Generally, Governor administers oath to the CGHC, that is Chief Justice of High Court, that particular High Court, and has delegated this oath administering duty of other High Court judges to the Chief Justice, because in Article 219 it has been clearly mentioned that he can either directly administer oath or he can delegate this oath administering duty to some other person. So he may administer oath. So as far as Chief Justice of that particular High Court, he directly administers oath to the Chief Justice of High Court. As far as other judges of that High Court is concerned, he may directly administer oath to them as well, or he can ask this Chief Justice of High Court that, hey, Chief Justice of High Court, and general practice has been same that he administers oath to this Chief Justice of High Court, and this Chief Justice of High Court administers oath to the other judges. But he may again, following this constitutional principle, he may directly administer oath to the other judges as well, right? Oath has been mentioned along with the judges, oath of to Supreme Court judges, right? Oath of High Court judges has also been mentioned into the third schedule. If you want to see the content of oath, so content of oath, that I'll be here true faith and allegiance to the constitution, uphold sovereignty and integrity, will duly and faithfully constitute to the best of my ability and knowledge and judgment, perform the duties of my office without fear, without any ill will, and will uphold the constitution and law. If you notice, right, these three are the content of oath of union minister as well, right. Will uphold and the constitution and law. In president's and the governor's oath, if you notice about this line, they take oath of that I'll preserve and protect the constitution and law, while these judges, Supreme Court judges, take oath that will uphold the constitution, not the preserve. And so that is one difference between the oath of Supreme Court judges, High Court judges, and the oath of president. So I hope the content of oath will also be clear to you. Now we are moving to the next slide and to discuss this salary and allowances. So salary and allowances of High Court judges has been discussed in article 221. So salary and allowances of High Court judges should be decided by the president, because president ultimately is the appointing authority, right? No, salary and allowances of the High Court judges will not be decided or determined by the president, but by the parliament. So these nitty-gritties you need to remember, that in relation to High Court judges or in relation to the Supreme Court judges, right, what functions or appointment, removal, president, what is the president's duty and what is the parliament's duty. So those nitty-gritties. So as far as salary and allowances is concerned, salary and allowances will be determined by parliament from time to time, right. They cannot, one caution that has been put up into the constitution again to maintain the independence of this judiciary, that they cannot be, once they have appointed. So suppose a particular High Court judge was supposed to get this 80,000 salary and some 20,000 as allowance, various allowances. So this amount will not be varied along his tenure. You can't say, of course, means except during this financial emergency, right, only during financial emergency this can be varied, but except this situation it cannot be varied by the parliament as well. So they cannot be varied to his disadvantage during his whole term except during financial emergency. As far as salary, like the Supreme Court judges, right, High Court judge salary is also charged expenditure, and his salary will be charged on Consolidated Fund of India like Supreme. No, his salary will be charged on the Consolidated Fund of State, not on the Consolidated Fund of India, that is union's fund, right. His salary wherever he is serving. So suppose a particular High Court right now is serving in this Jabalpur High Court, right, then his salary will be charged on Consolidated Fund of Madhya Pradesh. Now he is transferred to this Patna High Court, then it will be charged on Bihar's Consolidated Fund of State. So that was about salary. About the pension, pension will be borne by Consolidated Fund of India and not on the Consolidated Fund of State. Why this? Because in Supreme Court, see, in Supreme Courts you saw that the consolidated, his pension as well as salary both was being charged on Consolidated Fund of India, but here you do have difference, and difference is that while salary is being borne by the state, pension is being borne or charged on the Consolidated Fund of Union. So the difference is because during the entire length of his tenure, so suppose a particular judge served for 25 years in various High Court, suppose in 5 High Courts. So in 5 High Court he kept jumping from one High Court to another to another, right. So which state you are going to claim, because he has served all 5 states, right. So the logic can be that okay, distribute all the this pension across these 5 states, but that will be a cumbersome process. So just to avoid that cumbersome process, the pension has been, for the provision of pension has been made that it will be charged on the Consolidated Fund of India, rather than asking 5 or 6 states that hey, 5 or 6 states, can you contribute, right. So that would have been, so just to avoid that cumbersome process, right. So the meaning of charged you already know. As far as emoluments and these salaries are concerned, these salaries and emoluments has been discussed into the second schedule. So that you already know that in second schedule there are constitutional functionaries, there are bodies whose emoluments and allowances has been defined, and in third schedule you have this oath that has been defined. As far as presidents and governors oath is concerned, that lies directly into the constitution, we already have discussed, and not into the third schedule. As far as again their salary, presidents and governor salary is concerned, their salary again has not been defined in any of the schedule but in articles directly, right? So I hope that comparison would be clear to you. Now, I was talking about this nitty-gritty information, that what will be the role of, in which situation the role of parliament will pop up, in what all situation in relation to the High Court and Supreme Court, the president's role. So that has been consolidated here. So the number of judges will be decided by the president, appointment will happen by president, removal authority will be president. As far as retired judges, so who will take decision on the retired judges, whether retired judges should be appointed or not, right? So that decision although will be taken by Chief Justice, but with the consent of the president. Similar with the additional judges, salary and allowances will be decided by the parliament and not by the president. Oath will be administered not by the president but by the governor. So these nitty-gritties has been put up on this slide just to avoid the confusion, so that you can easily revise. So I hope this salary and allowances will also be clear to you. Now it is the turn of MCQ. So this is the first MCQ, second MCQ, third MCQ and fourth MCQ. So these are the 4 MCQ that I expect you to attempt. So until we come up with the second video onto the this High Court, till then, bye bye.